Professor Camilla Naidu, Executive Dean, Faculty of Humanities, Professor Eleanor Cornelius, inductee, Professor Alan Melby, respondent, Emeritus Professor at Brigham Young University in Provo, Utah, senior leaders of the university, members of Senate and other academics, distinguished guests, students, and to your family, which I say there's sons and husbands and daughters. No, sons, just sons. I was told that they had their own life. Don't hold your breath. All who have joined us online, Sanbonani, goeienaand, good evening, Tobela. It is indeed a great honor and special privilege for me to welcome you to the Professorial Inaugural Lecture of Professor Eleanor Cornelius. As I do so, I wish to express a warm welcome to her loved ones, special guests, and colleagues. This is indeed a proud and joyful, yet a landmark moment for all of you, for Professor Cornelius, for us here at UJ, for higher education in South Africa, and beyond. This is particularly noteworthy as we celebrate 20 years of UJ this year. Since the merger in 2005, we have come to exemplify how excellence and access are not mutually exclusive. In the spirit of innovation and social responsibility, UJ has pushed boundaries and prioritized research, technology advancement, and community engagement. It is against this backdrop that we welcome you into the professorate, a community of scholars dedicated to UJ's ethos of academic excellence while making a tangible impact on society. The inauguration of professors is a public ceremony in which newly appointed professors are inducted into office by the Vice-Chancellor and deliver their inaugural address. The ceremony has its roots in medieval university and serves multiple purposes. First, it is an expression of welcome, and it's an entry for new professors joining the circle of colleagues who are already professors. Secondly, it provides a platform for professors to display their expertise in the discipline and showcase their research. And we're looking forward to yours tonight. In the colonial tradition subscribed by many universities, assuming the role of the professor refers to the gown and the cap. Once we have listened to the inaugural address, the gown, denoting the professorship, will formally be assumed. Today, we gathered to witness Professor Eleanor Cornelius' entry into the illustrious community of scholars at our university. It celebrates her contributions to the discipline and ultimately her impact on society. Professors provide a university with its identity, character, academic legitimacy, and integrity. The inaugural lecture is a rite of passage, following the confirmation of the appointment of a person as a professor. This evening, we listen to Professor Eleanor Cornelius as the gown goes to town. By this, I mean that the power of the inaugural address is when the expertise is showcased beyond the corridors of the university and reverberates through society. It stands out as a moment of pride for the incumbent, the family, fellow scholars, the university, and ultimately the whole of society. In the past, several philosophers and scholars have defined universities using very narrow conceptualizations. For example, the search for truth, for universal knowledge, and even as an instrument serving the purpose of the economy or being utilitarian in the nature. Through our work and research at UJ, I hope that we can break out of these narrow conceptualizations and reflect on university as contributing to the public good, working towards societal impact. What is the role then of the intellectual? Edward Said, in one of his articles, defined the role of the intellectual as one who commands a vast knowledge of a specific discipline, one who is rigorous of the analysis of the literature, one who views being an intellectual as a vocation, and who functions as a kind of public memory to recall what is forgotten or ignored, to make the connections that are otherwise hidden, and to provide alternatives for mistaken policies. It remains then for us as a university with a Pan-African vision to derive our mandate as intellectuals and as professors, and importantly, how do we embrace the role of a professor as a disruptor while continuing to be a flagship carriers of our discipline. This evening, we will listen to Professor Eleanor Cornelius as one further step in the journey of being a professor. This is a journey which does not conclude once a lecture has been given. Notwithstanding this inaugural lecture does create an opportunity for a self-reflective pause in the journey of the professor. Let me now invite the Executive Dean, Professor Camilla Naidu, to introduce Professor Eleanor Cornelius. I thank you. Yelaboga, Nyabonga, baie dankie.
Vice-Chancellor Functionary, Mr. Dries Pretorius, Prof. Eleanor Cornelius, and family members who are with us today, discussant Prof. Alan Melby, Vice Deans Prof. Ragunanan and Prof. Harris, distinguished guests, friends, and students. It gives me great pleasure to introduce Prof. Eleanor Cornelius and share a synopsis of her CV. Prof. Eleanor Cornelius is an established scholar in applied linguistics at the University of Johannesburg, and she has been at UJ for close to 25 years now. Her research explores the intersections of language and the law, language accessibility through plain language, translation theory and practice, and multilingual communication within local and global contexts. Her doctoral thesis on the comprehensibility of plain language in the consumer industry, completed in 2012, established her long-standing focus on the relationship between linguistic devices, clarity, ease of cognitive processing, audience comprehension, and usability testing. This work laid the foundation for her subsequent contributions to plain language studies, translation pedagogy, and professional language practice. Prof. Cornelius was promoted to the rank of full professor in August 2021. She is an NRF-rated researcher at the C2 level. Prof. Cornelius has published extensively in accredited national and international journals, contributing seminal work on plain language, translation competence, interpreting practices, and language policy. She supervises honors, masters, and PhD studies, and as the first scholar to tackle the problem of plain language within a robust theoretical framework, she managed to build a critical mass of scholars working in the field. Her book, Gewone Taal, 'n Oorsig, Plain Language, an Overview, published in 2020, received the ATKV Woord Veertjie Award for excellence in the category Dictionaries and Style Manuals. In 2021, she received the Top Researcher Award in the Faculty of Humanities. Prof. Cornelius's scholarly impact has also been recognized by the South African Academy for Science and Art with the prestigious C.L. Engelbrecht Award for Linguistics in 2024. In 2025, she was a top 3 finalist in the Hewler Awards in the category Women in Humanities and Social Sciences. I think she deserves a round of applause for that. She is the co-author of Interpreting Terminology, published in 2018, a multilingual reference work in 5 languages. Prof. Cornelius served as a vice president of the International Federation of Translators for 3 years and as a member of the FIT Council for another 8 years, representing Africa in this global body for 11 years. Her term of office expired in September 2025 at the Statutory Congress in Geneva. She continues to be a vice person of the FIT Regional Center for Africa, which she helped establish in 2023. It is through these networks that she was able to bring on board Pan-African partners for Langsel at universities in the Cameroon, Kenya, Mozambique, and Senegal. Her involvement from 2014 to 2017 as the liaison between the German Research Center for Artificial Intelligence and FIT exposed her rapidly and ruthlessly to the field of machine translation and artificial intelligence. Managing a framework contract, QT21, funded by the EU's Horizon 2020 Research and Innovation Program, she was responsible for dissemination and outreach. It involved raising awareness of the QT21 project among professional translators through various publications and participation in high-level international conferences. In South Africa, she was appointed in 2023 by the Minister of Sport, Arts and Culture as a board member of the South African Language Practitioners Council, the SALPC, a statutory body regulating the language profession. She has served as chairperson and vice chairperson of the South African Translators Institute for a total of 9 years and is a SATI accredited interpreter. She also serves on the ISO's Working Group 11 for Plain Language through the SA Bureau for Standards. Prof. Cornelius integrates her research into transformative professional development in the language industry. As an applied linguist, she employs her scholarly insights to solve real-world language problems and to make an impact in various spheres of influence. For example, she played a pivotal role in training large corporations such as banks in the principles of plain language and the use of accessible linguistic constructions when the National Credit Act and the Consumer Protection Act came into effect and prescribed the use of plain language in consumer documents. So for all of us in the Faculty of Humanities, Prof. Eleanor Cornelius is an energetic and brilliant scholar and a pleasure to work with. We look forward to her inaugural address tonight. Let's welcome her with a warm round of applause.
Good evening, Vice Chancellor, Functionary Dries Pretorius, Professor Camilla Naidu, the Executive Dean, the two Vice Deans who are here in the audience this evening, Pragna Rugananan and Chad Harris, and all the guests who are here. Let me fire away. Clause 4.1.3 of Telcom's Standard Terms and Conditions for the Provision of Electronic Communication Services and Products reads as follows. Should a subscriber fail to notify Telkom of its election to terminate or renew the agreement, and more in particular where a consumer fails to notify Telkom of its election to either terminate or renew the agreement as permitted under Section 14 of the CPA, then the agreement will continue on a month-to-month basis on the same terms and conditions as contained under the agreement, except for the adjustment of the charges associated with a month-to-month term, and in the case of a fixed-line services subject, always to any variations in accordance with the tariff list or the product or service-specific terms and conditions. Any month-to-month agreement as envisaged in terms of this clause may be terminated at any time by either party by giving written notice to the other party. The linguistic complexity of this clause mirrors that found in the 2011 High Court case Standard Bank of South Africa Limited versus Dlamini. Judge Pillay criticized the bank's agreement as follows, and I quote, "For lawyers and laypersons alike, the form of the bank's standard agreement is an unappetizing, formidable read," end quote. Mr. Dlamini, a functionally literate 52-year-old male with no English proficiency, overlooked the repayment plan due to excitement when purchasing a vehicle. The terms were not fully explained to him, and important provisions were omitted or obscured. Judge Pillay found that the bank acted contrary to the National Credit Act, the NCA henceforth, and attempted to exploit its bargaining power, noting that even before enactment of this Consumer Protection Act, the CPA, its principles were well known. He remarked that financial institutions should embrace the NCA and the CPA as tools for reducing socio-economic inequality and promoting stability. And he said, I quote, "Institutions such as the bank should welcome the framework proffered by the NCA and the CPA for bridging the socio-economic inequality substantively and for reforming the credit industry, if for no reason but that sustained inequalities and need lead to unrest and social instability, which is not good for business," end quote. Regarding language rights, The judge highlighted that in terms of the NCA, consumers have the right to information in an official language that they understand and to plain, understandable language. For illiterate consumers, reasonable means must be used to communicate material terms, considering factors such as historical disadvantage, local language use, and industry context. The burden rested on the bank to show it had met these obligations. The court upheld Mr. Dlamini's right to rescind the agreement and ordered the bank to pay costs. A related matter before the Consumer Goods and Services Ombud in 2016 again involved consumer language rights. Section 22 of the CPA requires that an ordinary consumer with average literacy should be able to understand a document without undue effort. The Ombud ruled for the complainant, noting that the agreement was unclear to the point that even a lawyer would struggle to understand it. As is the human condition, there are always those who gamble with a gavel. This is what transpired in another case, Brandon versus Capitec Bank Limited in 2022, which involved a senior consumer with grade 11 education whose stolen cell phone was fraudulently used to withdraw 1.3 million rand out of her account. She reported the fraud only after discovering the withdrawals, but not when the phone was stolen 2 days before. The tribunal referred to the principle of caveat subscriptor, meaning let the person signing the contract be on his guard. This principle binds a party to an agreement regardless of whether they read it. Because Mrs. Brandon made no attempt to read the remote banking agreement before signing, her claim that it was not in plain language was deemed a bold allegation. Her arguments regarding the length and clarity of the document failed, as she had not read the document and thus have not even tried to understand the terms of the agreement in the first place. So let us look at legal protection against the language of the law. The cases I just discussed above, two of which favoured the consumer, highlight several key issues. Firstly, it is evident that language and the law are inextricably linked. Law is created and understood through language. Malley said in 1994 that legal language shapes social behaviour, yet it can also exclude those who lack access to its specialized forms and its high register. Traditional legal drafting and its strict genre conventions often function as barriers, including only those trained in this complex legal register. Those who are legally trained and can skillfully master this extreme variety of language are included in legal spheres and spaces, and they can participate fully and meaningfully in legal discourses and issues of governance. Those who do not have the linguistic competence to control the secondary discourse, which requires formal training at high levels in a particular discipline, are excluded and cannot participate in decision-making processes that may have far-reaching consequences for them. Judge Pillai's remarks in Standard Bank versus Dlamini illustrate this. Mr. Dlamini's limited English proficiency and low literacy placed him in a vulnerable position, while the bank, as the stronger party, used its advantage, undermining true freedom of contract. This brings into play the principles of sanctity of contract and freedom of contract. Each party is supposed to contribute freely to the terms of a contract that is binding upon them. We know full well, however, that Mr. Dlamini had no real ability to negotiate the agreement's terms. Talking about literacy, narrow views of literacy as the ability to read and write are now highly contested, as are conceptions of literacy as a one-dimensional construct. De Bruin, 2024, argues that literacy is culturally varied and that Western definitions disregard other meaningful literacies. Moreover, quantitative measures to test literacy skills are not always suitable in the unique multicultural and multilingual South African context. Again, in Standard Bank versus Dlamini, the plaintiff was labeled as, quite incorrectly so, functionally illiterate. You cannot be functionally illiterate. Anyway, functional literacy is defined by UNESCO in 2024 as the ability to use reading, writing, and numeracy in everyday life. Even if functionally literate, Mr. Dlamini still required explanations of the contract's material terms, which he did not receive. This contrasts with Brandon versus Capitec, where the applicant chose not to read the agreement despite arguably having sufficient literacy and general banking knowledge. These matters confirm that the National Credit Act and the Consumer Protection Act require consumer documents, especially for first-time or inexperienced consumers, to be in plain, understandable language. Plain and understandable implies comprehension on first reading, with minimal cognitive effort and the ability to find information or to solve a problem. The intent of the plain language provision is clear. Write in such a way that reading is greatly facilitated and use whatever aids to comprehension available to you. What is less clear, however, is how to determine exactly when a document is in plain language and whether it will be readily understood by a target audience, who is to a large extent an abstraction, despite the efforts of the legislator to describe such an audience rather meticulously. The Canadian lawyer and legal philosopher Phil Knight, who helped craft South Africa's plain language definition, argued that courts must consider whether a somewhat experienced reader and a novice debtor would be able to understand a document after reasonable effort. Courts should assess whether consumers grasp the document's communication, its connection to the credit arrangement, and its effects. They must also evaluate textual features, completeness, consistency, logical organization, vocabulary, and sentence structure, and the use of comprehension aids. Knight concludes that the plain language rule requires probable understanding and provides guidance for assessing it. The Plain Language Group of South Africa in 2010 praised the country's pioneering legislation, but warned that effective consumer protection requires clear standards for compliance and enforcement. A shared understanding of what plain language means is essential to avoid inconsistencies and weak implementation. I see plain language as a slippery slope of conceptual confusion. Let us go back to the 1800s. Jonathan Swift, author of Gulliver's Travels, published in 1726, was known for his humor, his irony and his sarcasm, and his social commentary on religion, colonialism, and inequality. In his Letters to a Young Clergyman, published in 1719, he famously claimed that style is simply a matter of putting proper words in proper places. While apt in its simplicity, this notion requires a far more rigorous interdisciplinary approach. Such an approach must be grounded in a strong theoretical framework, drawing on multiple disciplines, considering the interrelationships among language, memory, and cognition, to cite Carroll. Such an approach integrates the complex cognitive processes and psychological mechanisms that are involved in information and language processing, comprehension and production, discourse, and conversational interaction. Knowledge of such underlying psycholinguistic processes is then translated into practical guidelines and principles that will ultimately support the plain language practitioner to render a complex document in a readily understandable form. As Joe Kimball, an American attorney, a distinguished professor emeritus at Cooley Law School, and one of the most outspoken advocates for plain language, pronounced in 1992, at the height of the plain language movement, he said, and I quote, "It is no criticism that plain language cannot be precisely mathematically defined. Neither can reasonable doubt or good cause. Like so many legal terms, it is inherently and appropriately vague. And we have to settle for making it as clear and precise as possible. In fact, commentators recommend that plain English laws not adopt the precise standards associated with readability formulas. No one expects that every contract will be perfectly comprehensible, but we can expect that business and government will get off dead center and try to improve them. End of quote. In 2008, Neil James highlighted persistent confusion around the concept of plain language, noting that the field lacks coherence due to its many definitions. This points to the need for consistency and stability within the profession. Applied linguistics, as Crystal in 2003 explained, addresses real-world language problems by applying linguistic theory, thus precisely what is needed when making legal documents accessible. In 2015, Cornelius argued that the success of the Plain Language Project depends on the quality of the conceptual tools available to practitioners. Definitions of plain language abound to such an extent that Annette Cheek in America and her colleagues on the International Plain Language Working Group categorized them in 2010 into 3 types: numerical or formula-based definitions that rely on mathematical readability formulas, elements-focused definitions that take the form of a list of writing guidelines, and outcomes-focused definitions that consider how well readers can understand and use a document. This includes testing a document on a sample of real readers who fit the profile of the group of readers the document is intended for. Knight, in 2006, concluded that objective tests allow for technical compliance but substantive evasion, while subjective tests provide little legal certainty and expose industry to risk, an issue I will return to later. Following her analysis of the definition of plain language in South African consumer legislation, Cornelius concluded in 2015 that it has characteristics of both elements-focused and outcomes-focused definition types. The definition contains guidelines for readability and clarity in the form of a list of writing techniques and linguistic devices to be employed. Testing can indicate to what extent an ordinary consumer is able to understand effortlessly the content, the significance, and the import of a consumer document. For this reason, the role that testing and evaluation can play in providing access to information should not be underestimated. Empirical testing and statistical results can inform the guidelines according to which plain language practitioners should write or rewrite consumer documents for lay audiences. Testing can eliminate subjectivity or guesswork that may be inherent in the phrase, in the definition, that an ordinary consumer could be expected to understand. The plain language definition in the CPA and the NCA contributes substantially to eliminate the vagueness and the uncertainty that prevailed for a long time in the field of plain language and provides a springboard for constructing a robust plain language theory that provides a coherent, evidence-based framework that explains the principles and processes behind creating communication that people can easily read, understand, and use without jeopardizing the accuracy of information or fact. So let us reflect on the successes of the Plain Language Project in South Africa. Real-world language problems are approached in 3 phases, according to forensic linguist John Gibbons. Firstly, there is the reflection stage, during which the language problem is detected and investigated. Secondly, there is the action stage, during which the problem is tackled and an attempt is made to solve it. And lastly, the evaluation stage is there to determine the successes of the treatment or the intervention. I want to add an additional stage, considering the technological disruptions we are currently grappling with, and I will call this the future-proofing stage. I will explain later what I have in mind with this. It's now 18 and 14 years respectively since the NCA and the CPA came into full force. Today's lecture constitutes an attempt to evaluate its effectiveness of the plain language project in the consumer industry, and then to move on to the future-proofing stage with some recommendations and stern warnings. When South Africa became a democracy after the fall of apartheid, the reflection stage of the problem of the complexity of consumer documents commenced. I will discuss a few successes in relative detail. In this country, advocacy for plain language is a relatively recent phenomenon. Before 1994, the use of plain language was simply not a priority, according to Viljoen and Nienaber. The first success is the establishment of a legal framework within which the issue of the use of plain language, or the lack thereof, can be addressed and, if necessary, litigated. This was kick-started in 1994 by Mr. Dula Omar, who was then the Minister of Justice, who pushed for the transformation of justice and the democratizing of language. In 2009, Candice Burt, a South African plain language lawyer, commented as follows on the developments in the consumer industry at the time. For plain language advocates around the world, having so many plain language laws may sound like winning the first, second, and third prize all at once. Part of the reason is that in South Africa, law as a tool for change is the only way to expedite remedies for the inequities of the past. We didn't have a culture embedded in the rule of law, where unwritten constitutions govern how people behave. We didn't have a history of respect for human rights, a general morality based on seeing others as equals. We didn't have a process for lobbying for change. In other parts of the world, the struggle for plain language was far more challenging and prolonged. Pressure by consumer organizations in the 1960s and 70s gave rise to the development of the plain language movement, with some successes achieved, of which the biggest is arguably the passing of the Plain Writing Act of 2010 in the USA, signed into effect by President Obama. It is, however, safe to say that the road to achieving plain language legislation in South Africa was far less bumpy, given the strong focus on human rights after 1994 and the enactment of a substantial number of human rights acts with the objective to redress the injustices of the past. At the start of the lecture, I alluded to some notable cases in which the use or non-use of plain language was contested. The thoughtful way in which the courts and regulatory bodies approach the problems of compliance with the plain language provision is truly remarkable and commendable. Additionally, the courts and regulators do not fall into the trap of applying readability formulas to the contracts in dispute to determine whether they are in plain language. The use of readability formulas in isolation from other measures is not advised, as such formulas reveal very little information about a reader's background or domain knowledge, their motivation to read a document, their emotional state when signing the agreement, and so forth. The shortcomings of readability formulas, who are fast proliferating with the development of new technologies, without taking extra textual factors into account, are widely known. A second success of the Plain Language Project is the degree of sincerity and urgency with which credit providers such as banks and other role players in the consumer industry approached and continues to approach the plain language prescripts. This was a serious concern of Burt, who warned in 2009 that, and I quote, plain language initiatives driven only by compliance run the risk of implementing superficial, objective criteria, which do not necessarily give information that truly helps the consumer to make informed decisions. End quote. Granted, there are those cases in which contracts were found to be lacking in terms of its compliance with the plain language provision in the NCA and the CPA. But overall, given the massive number of consumer contracts that are entered into daily in South Africa, litigation seems to be rather isolated. Staff members in legal divisions in banks were initially truly skeptical about the use of plain language in complex, legally binding documents, without the loss of accuracy and precision, and with retaining the same legal effect. But Cornelius in 2016 experienced firsthand a gradual shift towards a more positive and accepting mindset after they have been exposed to ways in which this can be achieved. Two of the myths about plain language described in 1994 by Joe Kimball were soon debunked in the local consumer space, namely that plain language cannot replace legal language, as the latter contains many technical and specialist terms, and that plain language is not attainable as a goal, as the complex ideas that underpin the law require precision and accuracy. In her appraisal of plain language in the banking sector, Cornelius investigated how South African banks approach the plain language project. She was curious as the rare mix of legal knowledge, knowledge of language, and knowledge of text linguistics can hardly ever be found in one single person. Her findings indicate that there are high levels of cooperation in the three large banks in South Africa who participated in her study, specifically between the legal, the language, and the compliance divisions. Moreover, banks have strict signing off procedures in place to ensure that the legality of documents is not exposed. Further proof that the financial services industry is indeed taking the plain language imperative seriously is revealed by the findings of Cornelius' study and then affirmed by the 2024 study by Amanda Lander, who both found that the demand for plain language far exceeds the demand for other language services such as translation, editing, and transcription. A third success is that the consumer industry turned to applied linguists in South Africa who quickly responded to the call for guidance on how to achieve plain and understandable language in consumer documents. Scholars conducted rigorous scientific inquiries with the aim to advise and guide industry on how best to approach the plain language imperative within a strong theoretical and empirical framework. From 2010 to date, we have seen a focus in South Africa on the topic of plain language in academic journals, book chapters, books, MA dissertations, and PhD theses in the different domains in which plain language is required. Two notable scholarly contributions are the model for plain language in the banking sector developed by Cornelius in 2016 and the model for plain language implementation in English language package insert leaflets in the pharmaceutical industry developed by De Bruin in 2024. The scholarly contributions are noteworthy successes, pointing to the societal and industry impact of research undertaken in the field. A fourth success relates to subsection D of the plain language definition in the two acts, which alludes to aids to reading and understanding, such as the use of illustrations, headings, examples, and so forth. A commercial attorney from Cape Town, Robert de Roy, develops legally binding comic contracts by using pictures to help vulnerable illiterate people to independently understand contracts, to guide certain behaviors, and to ultimately improve the relationships between the parties to the contract. Examples of such visual agreements are employment contracts in the agricultural sector, financial services contracts, school contracts, and healthcare guidelines. Pete Cassello and Kikalioma Puha from Tampere University in Finland in 2019 referred to the comic contract as a type of intersemiotic translation, presenting the contents of legal documents in visual form. These comic contracts represent out-of-the-box thinking, creative courage, and intense daring to move away from the frozen, traditional styles of legal drafting that serve lawyers, and mostly only lawyers. A fifth success is that some South African universities, but really not many, have woken up to the need to incorporate knowledge of plain language principles and the comprehension difficulty posed by some lexicogrammatical constructions and text features into their training of language practitioners. An example is the University of Johannesburg. Training in plain language theory and practice is included in a third-year module on text editing and 1 full semester in the honours program in applied linguistics is devoted to plain language, the adaptation of text in different formats for different audiences, and document design. A last notable success is the adoption in 2023 of the first version of the ISO standard for plain language, ISO 24495. South Africa is a member of the working group, ISO TC 11, the working group, represented by the South African Bureau of Standards. In this way, South Africa was able, through the SABS, to provide inputs in the plain language standard, which was adopted in March 2024 as a South African national standard. The standard hinges on 4 principles: findability, understandability, usability, and credibility. Now I get to the future-proofing stage in the applied linguistics cycle. This is the stage that I decided I want to add. As much as the successes of plain language are remarkable, the industry should take care to future-proof these successes. And this is the stage that I want to add to the applied linguistics cycle. We are all aware of the rapid development of technologies, including generative AI. People use large language models such as ChatGPT 4.0, ChatGPT 3.5 Turbo, Claude 3.7 Sonnet, Gemini 2.5 Pro, and Llama for a vast variety of tasks, including translation. These models can also be used to translate intralingually existing complex documents into plain language. Whereas comic contracts are seen as a type of intersemiotic translation, Cornelius in 2010 regards plain language work as a type of intralingual translation, another translation type that Roman Jacobson first suggested in 1959. In addition to interlingual translation, large language models can also do intralingual translation, seemingly with impressive results. For today's lecture, I prompted ChatGPT to translate the clause from the Telkom agreement that I started this lecture with into plain language. The result is astounding. When I prompted the model to explain the principles it relied on during the task, it was able to explain the approach it followed with examples of translation shifts from source text to target text. The principles it followed include use of everyday familiar words, shorter sentences and clear structure, logical sentencing, signposting, clear formatting, visual organization, consistency, transparency, and a reader-oriented perspective. It also mentioned that it took into consideration the ISO standard with its 4 core principles that I mentioned just now, and demonstrated how it mapped its plain language version on these principles. So it seems we can easily call on large language models to take over the plain language imperative in the consumer industry. Or can we? What I have not yet done, purposefully, is to compare the complex original to the resulting automatically generated output. I promised Professor Alan Melby, my respondent, that I will do this as a matter of extreme urgency. But I wanted to put myself in the shoes of a person who is not able to compare the source text and the target text. Most people cannot do such a comparative analysis as the source text, the original, exceeds by far their linguistic competence. And this is where a huge problem arises. As the output makes for an easy read without having to expend excessive cognitive resources, and as there appears to be no hallucinations or lack of coherence or cohesion, it is easy to accept that the product is fit for purpose. But what about the issue of risk? What about the consequences for credit providers and consumers alike? It seems there is now a new need to protect the consumer. This time, the protection does not arise directly from opaque and convoluted language, but from using unverified output of automatic translation systems. According to Alan Melby in 2024, output can be the work of a professional translator or yes, on the one hand of a spectrum, or the raw output from an automatic translation system on the other. Important, though, is that the end user is often completely oblivious to what kind of output it is that they are reading. If the output reads fluently and easily, the end user is none the wiser and will not know that the target text does not correspond to the original. There may be errors of omission, commission, or addition that can jeopardize the legality of the document. And such errors can lead to damage and risk in high-stakes use cases. I want to believe, and Professor Malby can either agree or disagree, that I somehow contributed to the debate of protecting the consumer against practices where automatic output has not been verified by a professional. Where did this start? In 2021, we organized and hosted a panel discussion at the ASLING 43rd Annual Translating in the Computer Conference. I was the moderator of the panel with Professor Malby as the co-moderator. The topic was unedited raw machine translation, strengths and limitations in your use case. International experts from various organizations participated, including the head of the European Commission's e-translation service, the current president of the International Federation of Translators, Guillaume de Neufberg, the head of the press unit at the European Committee of the Regions, representatives from translation companies, and researchers. The outcome of the discussion was that there are use cases where the use of raw automatic translation without any human intervention is appropriate. But then there are use cases where the risk is simply too high. The use of disclaimers on web pages that use raw automatic translation surfaced during the panel discussion, where the turnaround time for these websites are extremely tight. And so the idea of consumer protection by labeling the end product was born. Malby proposed this kind of protection as provided in many sectors of the consumer economy, such as the food industry, with labels indicated that the product is gluten-free, that the product is halal, vegan, whatever it may be. Malby continues to work on the labeling project with a team consisting of 2 standing committees of the International Federation of Translators, the American Society for Testing and Materials, ASTM, and Altec's Global Tranquility Division. Over the course of the last 3 years or so, the team has refined the underlying principle. The basic premise is that automatically generated output should carry a label to indicate whether it has been verified or not. Verification can either be self-revision, revision of a translation done by another translator, or post-editing of automatic translation. In our case today, I add the professional plain language practitioner to the list. Qualified translators and plain language practitioners are best suited to perform the verification. This entails checking for correspondence between source text and target text. The label, professionally verified translation, indicates that the translation output meets the agreed upon specifications and its use, and placing a logo indicating such verification on the product should instill confidence in the consumer. The label unverified translation is used for everything else, including raw automatic translation and translation involving non-qualified, non-professional humans. Labeling an end product as an unverified raw translation and putting a logo on it to indicate that it's not a verified translation will warn consumers to take care when using the translated product to make important and high-risk decisions. Professionally verified translation requires the involvement of a qualified human, and the human accepts responsibility for correspondence errors in the end product. Accountability begins with an individual translator or an experienced plain language practitioner who attaches the label professionally verified translation to their work before submitting it to the client or the consumer of the end product. This establishes a chain of trust and accountability all the way to the consumer. In the case of unverified raw automatic output and translations performed by non-qualified, non-professional translators or individuals, the question of ownership of any potential errors and consequences that may arise hangs in the air. These errors and consequences may lead to serious reputational damage to the creditor provider and consequently cause harm to the consumer of the product or services. If these labels are used and accompanying logos are placed on end products, public awareness of the distinction verified versus unverified and the risk that comes with using unverified translation or plain language products will be raised. Now, a few recommendations on how to future-proof the Plain Language Project. The successes of the Plain Language Project are evident in many spheres of society, even beyond the consumer industry. It is par for the course that there is still some work to be done by some consumer companies and financial services providers, as highlighted at the start of this lecture. In my opinion, it is fair to say that role players in the South African consumer industry have risen to the challenge of the plain language imperative and have been trailblazers for the use of plain language in customer-facing documents. Plain language work is highly demanding in terms of cognitive resources and it's therefore time-consuming. It would be a pity if shortcuts are taken to save time and cost, as these perceived savings could result in more money being spent in the long run when there is litigation and risk of various kinds involved. One such shortcut would be to use unverified raw automatic plain language rewrites without the human in the loop. In terms of policy impact, my recommendation would be that current plain language legislation be amended to mandate the use of labels and logos on plain language products to indicate verification or non-verification by a qualified professional plain language practitioner or a translator, a process currently underway in the US and elsewhere. The adaptation of the current labels and logos for use in plain language contexts should be investigated, and rather urgently. Lastly, I want to urge the Department of Sport, Arts and Science to reinstate the South African Language Practitioners Council, SALPIC, established in terms of the South African Language Practitioners Council Act in 2014, to regulate the language profession, to set standards for training, accreditation and registration of language practitioners, and ultimately to protect public interests. Its untimely disbandment very recently, due to legal technical reasons, is causing serious harm to the profession, and the language practitioners and the public receives no protection in this regulatory vacuum. I foresee that this council, if reinstated, can play a decisive role in the protection of the consumer using labels and logos. Thank you. Please allow me a few more minutes just to thank a few people. Thank you to my husband. Life is so much better with you in it. Thank you to my children. You bring me so much joy. To my family, for your unwavering support and your unconditional love. Some are here and there are those who are online, I believe. My friends, those that are here and those online, I adore you all. My colleagues, you continue to inspire and amaze me. We are an unbelievable team. My students, my former students, I learn from you every day. My HOD, Cindy Ramhari, you are a manager par excellence. The Dean of the Faculty, Prof. Naidu, I appreciate your personal encouragement greatly. To my colleague who interpreted today, Sebastian, I'm sorry I made it very difficult for you. Thank you for building bridges and removing linguistic barriers. to the great University of Johannesburg and its leadership. You have been good to me for 25 years. Every day in this job has been filled with sheer joy and just the right amount of pressure and anxiety to propel me forward. And then lastly, I want to thank my colleague and my dear friend, Professor Alan Melby, who will be the respondent today. I hope you enjoy his contribution. Thank you very much.
It's a great honor to be invited to participate in this glorious event. Congratulations, Eleanor, Professor Cornelius. I would like very much to be there in South Africa with you. It was not feasible because yesterday I had to be in Brussels, and tomorrow I have to be in Paris. But here I am remotely. I hope that you can hear me despite the great distance, but my heart is with you. So let me make a few comments as the respondent here. First of all, Eleanor, congratulations on practicing what you preach. Your exposition on plain language is a masterpiece of plain language. I am not an expert in that field, yet I could follow it. And that is evidence of your expertise. So, the next thing is this. I'll answer your question. You asked me whether I would agree that you were part of the beginning of the Labels Project. And I would say, definitely. Actually, you were a major part. I remember clearly the panel discussion in November 2021 and the various discussions it led to, including my insight that labels on translation output should be part of consumer protection, just as other aspects of consumer protection are important to society. This is an important one. We don't usually think of consuming text, but it makes sense, and it makes sense to people. They consume a translation, and they need to know what they're consuming. They need to know about it. So thank you, Eleanor. I doubt this whole project of labels on translation output would have gotten started without you. Now, I'd like you to please note that the new insight that Eleanor had and presented during this lecture, the new insight of the close parallel between, on the one hand, translation, interlingual translation, and on the other hand, conversion from extreme forms of language, high register legal language, and other extreme forms, to plain language, which can be considered, as you pointed out, intralingual translation, are actually, in the broad sense, two forms of translation that both need to be labeled. I am just taken aback by this insight, which I think will be powerful in the coming years. So let's look at the parallel. You pointed out labels and logos as to whether this output has been, whether it be intralingual or interlingual, whether the output has been verified by a qualified professional. It's the same insight. It's the same need. The labels should be quite similar, and the logo could be very similar, possibly even identical. We'll see how things evolve. This will provide some synergy between the two needs, as you have explained, to future-proof. I love this term. You have helped us provide a way, you've provided to us a way to future-proof advances in plain language. And it will also contribute to future-proofing developments in automatic translation, because there will always be a difference, in my opinion, a difference between humans and machines. No matter how good they are, no matter how powerful they are, they will be different. And this difference is what makes it important to label something as raw automatic translation or non-qualified human translation, unverified, versus verified by a qualified professional. The need for qualified professionals who really can take into account all the factors in a text, whether it is plain language, whether everything that's essential has been captured, whether there have been any distortions. It's the same for interlingual and intralingual. Thank you so much. I'd like to point out one more thing. You have pointed to the future, talking about future proof. You have demonstrated just in the last few days things that you had no idea would happen when you were writing your lecture, things that have happened that confirm your approach. Just weeks ago, the Chinese government announced legislation to require labels on AI-generated output, including text, with all kinds of text, including translation, including plain language that supposedly corresponds to the source. We'll see how this evolves in coming weeks and months, but it's very important because you can infer from a label Gen AI or AI generated, you can infer unverified. Another thing that happened just a few days ago, after your lecture was submitted to the university, November 5th, the European Union issued a press release saying they're starting a study of labels on AI-generated output of all kinds. How timely your lecture has been. I'd like to end by saying the world demands, the world we live in, the world of artificial intelligence, demands professional verification of output to protect consumers, to provide transparency, and to manage risk. Professor Cornelius, Eleanor, if I may, thank you very much for your lecture.
we give Professor Cornelius another huge applause, please? I have to say that was fascinating. I really did enjoy it. I'm a lawyer by trade, but I'm one of the old school. I prefer the difficult language over the easy language. But point taken, noted. I think we could all benefit from the work that you're doing. Thanks again very much. That's the end of the occasion. You're invited to join us for some snacks and for some celebrations in the room next door. Thank you very much.